Good morning. I'm very happy today to introduce Carmen Barroso. Carmen is a professor at the Open University of Madrid. And she agreed to hold this lecture for us. We would have preferred to have her physically in Trento, but current events do not allow it. Hopeful in the next year, I hope. However, we are grateful that she also wanted to participate in our course with this modality by video conference. Thank you very much,
Thank you,
Carmen, for your
participation with us. And I'm happy to have you here, and I hope to see you next year in Trento. So please, you can introduce your interesting lesson.
Thank you very much. First of all, I would like to thank Professor Magliaro and Professor Ariati for giving me the opportunity to have this contact with the University of Trento. As the professor has said before, I'm Carmen Cámara Barroso, professor of the Madrid Open University. And the main aim of this presentation is to introduce you the most important aspects related to the European Court of Justice, and also the importance of the 4 fundamental freedoms in the field of direct taxation at a European level. Oh, excuse me, this one. Since its creation in 1952, the main aim or the main field of the European Court of Justice is the safeguard the proper interpretation and application of the treaties, and also the compliance with the EU law by the different member states. The Court of Justice of the European Union, which has its seat in Luxembourg, is divided into different courts, the Court of Justice and also the General Court, with different field of action. As said before, the role of the European Court of Justice, the ECJ, is review the legality of the acts of the different institutions of the European Union, as for example, the European Commission or the European Council. Also, to ensure that the different member states of the European Union comply with their obligation under the primary law, the treaties. And finally, also interprets EU law at the request of the national courts through the preliminary rulings proceedings. As we have said before, inside the European Court of Justice, we can distinguish between the European Court of Justice and the European General Court. Inside the first one, we can find 27 different judges and also 11 advocates general. The role of these advocate generals is to give a partial opinion to help the judges have a decision on the final case. Inside the Court of Justice, we can distinguish different types of proceedings. The first one, and maybe the most important one, is the preliminary ruling. Through this kind of proceeding, different national courts can ask the Court of Justice for give an opinion about the proper or not application of the European Union law inside the different countries. So to check if national law is compatible or not with the European Union law, and in particular with the treaties. Apart from this proceeding, apart of this proceed, we can also speak about the action failure to fulfill obligations. In this second type of proceed, the European Court of Justice try to determine if a member state comply or not with its obligation under the European Union law. In this case, before the appeal to the European Court of Justice, usually the European Commission starts a preliminary procedure against the member state that is not complying with the European Union law. If the member state decide not to change its national regulation or its domestic legislation, in this case is the Commission the one who decides to go to the European Court of Justice. So in the previous one are national courts, those who can access to the European Court of Justice, but in this kind of proceed is the European Commission the one who started the process before the court. And finally, we can also have actions for the annulment of different acts from the different institutions of the European Union, for example, the directive, regulations, and so on. So inside this first part of the European Court of Justice, the Court of Justice, we can find these different, with the three different kind of proceeds. By its part, General Court also have a field of actuation. In this case, we can we can fight through the General Court against the following situations. For example, actions. We can fight against action from the different institutions of the European Union that affects directly one national of any member state, a natural person or a legal person. We can also fight against actions from the European Commission. So us, as member state, can appeal to the General Court litigating against the European Commission. And we can finally also go to the General Court for issues related to the state aid regime of the European Union. Finally, I would like to add that we can also appeal for the decisions of the General Court to the Court of Justice in 2 months. Once we know more or less how the European Court of Justice works, the second part of this presentation is related to the role of fundamental freedoms for direct taxation. As we all know, the central basis, the more important part of the EU internal market is to reach non-discrimination between cross-border and national situations. As we all know, the 4 fundamental freedoms that we have inside the European Union are free movement of goods, persons, services, and capital. And those fundamental freedoms are a manifestation of the principle of non-discrimination. As we have said before, these 4 fundamental freedoms have a very important impact on direct taxation through the interpretation of the European Union treaties done by the European Court of Justice. If we think about the importance of the fundamental freedoms for direct taxation, we can divide it into different groups. For example, for free movement of person, and inside this free movement of person, we can distinguish between free movement of workers and also freedom of establishment, things related to direct taxation that can be influenced by fundamental freedoms are the following. It's just an example. For example, in the field of free movement of workers, we can find different cases of the ECJ regarding the deductibility of different kinds of expenses, for example, personal allowance or social security contributions, and as we can see, and we will see in another video, if these expenses has to be taken into account in the residence estate or in the source estate. Regarding the freedom of establishment, here we can find some different cases related, for example, with the existence of a permanent establishment in the source country, with the taxation of group of companies and the different treatment between national group of companies and cross-border group of companies, and also issues related to exit taxation. If we move to another fundamental freedom inside the primary law, we can find the free movement of services. In these cases, those regarding free movement of services, mainly we can find cases related to the deductibility of expenses, as for example interest, and also the application of withholding taxes, for example in the case of services done in the source country but by a resident of another country. And finally, the most important one, not the most important one, but maybe the more controversial one, is the free movement of capital. One important thing that we have to highlight is that this one, the free movement of capital, is the fundamental freedom that applies not just inside the European Union between member states, but also in respect to third countries. So if we can go back and as we have said, we have free movement of goods, free movement of persons, services, and capital. So this one, the free movement of capital, is the one that also applies to third countries situations, situations in which third countries are involved, but not just in the European Union context as the others don't. And in this case, in the cases, we can find some different cases of the ECJ applying the free movement, the application or the interpretation of free movement of capitals, in particular regarding the taxation of dividend payments in cross-border situations. So once we know more or less the impact that the fundamental freedoms can have in the field of direct taxation at the European level, we can quickly review how the European Court of Justice interpreted if there is or not a restriction of a fundamental freedom in a situation in which direct taxation or direct taxes in a country of the European Union can have. As we have said before, when we as national court ask the European Court of Justice for the interpretation of a national legislation or a national regulation in order to check if it is in line or not with the European Union law, we are going to use a preliminary procedure. On the contrary, if it's the Commission, the one who understands that a national legislation is not complying with the European Union law, we will use an infringement procedure started by the European Commission. So the previous one, preliminary procedure, is started by a national court, an Italian one and a Spanish one, but the infringement procedure is started by the European Commission. Anyway, for example, taking as an example a preliminary procedure as we have said in the slide before, the European Court of Justice is going to follow a 4-step system to determine if a concrete national legislation is or not doing a restriction of any fundamental freedom of those 4 that we have mentioned before. First of all, the 4 steps are the following. First of all, the European Court of Justice is going to examine if the case falls within the scope of any of the 4 fundamental freedoms. And for this, we have to have a cross-border element, so at least 2 member states participating in the problem, and also we have to have at least an European Union person, natural person, or company. So if we are talking about an internal situation, a domestic situation, just with one country taking part, in this case we cannot go before the European Court of Justice. So we need at least 2 member states implied. In the second step, the European Court of Justice is going to evaluate if there is or not a restriction of a fundamental freedom. And for this, the ECJ is going to compare the cross-border situation with a similar internal or domestic situation. In the third step, the ECJ is going to check if testing in the previous step that there is a restriction of any fundamental freedom, maybe in this third step, the ECJ is going to the conclusion that maybe also existing this restriction, there is a possible justification for the not compliance with the fundamental freedom as established in the treaties of the European Union. And finally, once the European Union has found as justification for the restriction of the fundamental freedom, it's going to check the proportionality of the measure implied. So in the first step, as we have said, we have to compare a cross-border situation, the ones in which the problem arises, and also we have to compare this cross-border situation with a similar hypothetical situation in the domestic context. So we are, for example, talking about a group of companies. We are going to check the situation of a group of companies in which the parent is located in Spain and the subsidiary is located, for example, in Italy, with the same situation inside the same country. For example, a group of companies inside the Spanish territory. Second, if the ECJ discovered that effectively the cross-border situation is not treated in the same way that a similar situation, a similar domestic situation, we can affirm that we have a restriction that implies a discrimination, a restriction of one of the 4 fundamental freedoms. For example, in our example of group of companies, maybe a restriction of the freedom of establishment. Once we have discovered this restriction of a fundamental freedom, of the fundamental freedom of establishment, the following step is identify if we have, or if the country have justification for this restriction. If we analyze the previous cases of the ECJ, we can find some different general interest justification causes. In this slide, we can see that we have the justification that has been accepted by the ECJ in previous cases, and also some justification not accepted by the European Court of Justice. Inside the first group, we can distinguish, for example, the cohesion of the tax system, and this means that the ECJ understands that the state that allow for example, the state that allow a deduction of expenses is the same that has the right to tax the income obtained by a natural person or a company. So this is the cohesion of the tax system, that maybe it can be a cause of justification for the ECJ. In second term, for example, a balanced allocation of taxing power. So for the ECJ, territoriality is also, the principle of territoriality is also a justification for the restriction, or can be a justification for the restriction of fundamental freedom. The prevention of tax avoidance also can be assumed as a justification for the discrimination or the restriction. And finally, the effectiveness of fiscal supervision and tax collection. Maybe nowadays that we have very strong or very important system of automatic exchange of information, in these cases, in the cases that we are going to have in the future and the present cases of the ECJ, maybe this last cause of justification is not used anymore, because we have exchange of information system that can provide us the information that we need to a proper control of the fiscal tax collection. And finally, the 2 causes of justification not accepted by the European Court of Justice are those: one, the loss of tax revenue by a national state is not considered as a justification for a restriction of any fundamental freedom for the ECJ, and neither the difficulties in obtaining information, as we have said before. Inside the European Union, we have important system for this exchange of information.
Well, Carmen, if you want to finish maybe with the slides, and then we can make a little break after this first framing of the procedure, if you agree.
Yes, as you want. Okay, perfect.
Okay, you can finish this one.
Yes. In fact, this is the last one. So
okay, perfect.
Okay. So
Perfect.
the last. Thank you. Excuse me. And the last step of this 4-step analysis done by the ECJ is the proportionality one. So once the European Court of Justice has decided that we have a justification for the restriction of any of the fundamental freedoms, we have to check if this measure, the national measure, is or not proportional. So we can understand proportional by 2 different things. If the measure is suitable to achieve the goal protected, the cause of justification that we have discovered in the previous step. And finally, being suitable to achieve this goal. This measure goes beyond what is necessary to achieve this goal, or is balanced with the obtaining of the measure wanted by the national law. That's all. Thank you very much for your attention.
Perfect. We stop this first part and then we call you for the second one.